Now we're going to switch to the other side of the law. And we're going to have our criminal panelists come up. And while they do that, are they good to go? And I think we have a monitor that we need to set. Okay, good. God, it's amazing. Can I just, while this is happening, I just want to do a huge shout out to Sheila Weiner and her team who have been arranging all of this. They're just amazing. Please join me in thanking them. All right, come on up. So what we just saw was civil law. Now we're going to be talking about the criminal side of the house, the prosecutors, and what kinds of criminal theories can be brought in these kinds of cases. And I am privileged again to have one of my colleagues here, and Shirlithia, who you just met, is one of the co-chairs of the Jones Day Hate Crimes Task Force, the pro bono work that we do on behalf of victims of hate crimes. One of the other co-chairs you're going to meet later, and the third is here, Andy Luger. So it's my great privilege to turn over the panel to my friend and partner, Andy Luger.
Good afternoon. So we look a little different than the last panel.
You think?
Just want to make sure you're awake. Shirin, can you hear us?
Yes, I can
Great.
hear you.
So my name is Andy Luger. I'm a partner in the Minneapolis office of Jones Day and a former U.S. attorney for Minnesota. I'll be moderating this panel discussing criminal approaches to hate crimes. And so before I launch into what we're going to talk about and how we're going to do it, I'm going to ask each of the panelists. I was going to do this differently, but I saw Shirlithia. I like the way Shirlithia did it. So I'm going to have each panelist introduce themselves, say a couple of words, and then we'll get into the discussion. So, Tom?
Yep, I'm Tom Brzozowski. I'm the Counsel for Domestic Terrorism at the Department of Justice.
My name is Eric Dreiband, and I served as the Assistant Attorney General for the Civil Rights Division at the U.S. Department of Justice, and now I'm in private practice in Washington, D.C.
My name is Tim Lewis. I am a seventh-generation Pittsburgher and a native of Squirrel Hill who grew up 3 blocks from Tree of Life Synagogue, and I'm a lawyer. Thank you. I'm a lawyer, former federal judge, and I live and work here in Pittsburgh.
My name's Justin Herdman, and I'm a Cleveland Browns fan.
Oh, no, you didn't.
Currently in private practice in Cleveland, Ohio, but formerly United States Attorney in the Northern District of Ohio, and also served as an Assistant U.S. Attorney in the same office, working national security cases.
Shirin?
My name is Shirin Sinnar. I'm a law professor at Stanford University. I study and teach on the legal treatment of political violence and national security and civil rights issues. I was previously a civil rights lawyer in San Francisco.
So what I think we want to do is kind of demystify criminal prosecution of hate crimes. You heard about the civil litigation approach to hate crimes and sort of novel approaches that people are taking in the heartbreaking story of Tanya Gersh this morning. And I'll confess I wanted to be on that panel with Tanya Gersh, but I wasn't invited. So we're going to talk about, sort of in broad terms, 2 broad categories of hate crimes that are prosecuted both at the state and the federal level. The first is domestic terrorism. Organized hate groups, whether they're white supremacists or neo-Nazis or others, you'll hear a little bit about the work that the Department of Justice and others do to address organized, politically motivated, ideologically motivated hate crimes in the domestic terrorism context. And the second are what are more typically referred to as hate crimes, more individually focused types of crimes. And one of the things we're going to try to do in our discussion, and I'm going to ask each panelist to talk for a few minutes, and then we'll have a broader discussion, is one, what are the boundaries of the criminal law? We have novel approaches to civil litigation against those who intimidate, harass, and otherwise invade the lives of victims. But where does the criminal law play a role? Could the criminal law have been applied, for example, in the matter and what happened to Tanya Gersh? And then second, what are the roles of victims and the community when a criminal case is brought, because the victim and their families are not actually participants, they're the victims, they're not named litigants, and what are their roles and how do they play in. And then third, and there'll be 4 of these topics, the third is the role of civil liberties. Whenever criminal prosecutors get involved, whenever the criminal law gets involved, we always have to be careful and take a step back and make sure that while we're protecting people from harm, we're also protecting free speech and the ability of people to express themselves as to their views. You heard a little bit about that on the last panel, and it plays an even greater role for those of us who have been prosecutors in thinking about where those boundaries are. And then finally, how these cases are investigated, and there's some controversy to this. Many of us are veterans of the war on ISIS recruiting, Al-Shabaab and Al-Qaeda recruiting in the United States, and the use of informants and the use of other investigative tactics raise questions that we'll be talking about, and I'm going to invite some back and forth on those issues because they are controversial and there can be disagreements. We want to bring that out as we think about how we're going to protect our communities, our society from hate crimes without giving up who we are as a country and our civil liberties. So Tom, I'm going to start with you. If you could do just a few minutes on the work that you do as a counsel for domestic terrorism, what domestic terrorism is, and maybe just a little bit of some of the cases that you've brought against organizations like Adam Waffen and others.
Sure, absolutely. My role as counsel for domestic terrorism typically requires me to try to maintain a holistic view of all things that concern domestic terrorism as we understand it in the department. So I suppose the first order of business is to let you know how we understand domestic terrorism in the Department of Justice. There's a statutory provision which actually defines domestic terrorism, but in lay terms, effectively, we understand domestic terrorism to mean any individual or group of individuals who seeks to give expression to any ideology through violence or threats of violence, and that's it. And those acts have to typically occur within the confines of the United States. So it's actually fairly straightforward. Again, anybody or any group that is seeking to give expression to an ideology of any kind through force or violence or threats thereof would be construed by the department as potentially being a domestic terrorist. I wanted to also give you a couple of other top-line points that might help clarify how we understand domestic terrorism before we dive into some of the particular issues that were noted earlier. Again, as I noted before, we have a statutory definition in our Title 18, which is our criminal code, that defines domestic terrorism. And it's 18 U.S.C. 2331.5 if you want to look at it. But the interesting part about this particular provision is that it does not criminalize domestic terrorism per se. It merely defines it. And as a consequence, the majority of the charges that we bring on the federal side of the house in connection with domestic terrorism activity typically do not relate to terrorism charges at all. In fact, many of the charges are fairly garden variety gun, weapons, explosives charges, and what have you. You'll hear later on in the panel that a large majority of the charges that we bring concern hate crimes. That brings me to another point that's important that folks understand. You may be familiar with what's described as a foreign terrorist organization list. In the legal community, that's very important because if one were to provide material support to an entity that is on this foreign terrorist organization list, that's a federal crime. However, what's critical in the domestic terrorism side of the house is that we have no analog to the foreign terrorist organization list. That is to say, there are no official domestic terrorist groups out there, or there's no official government list that purports to list entities that would be understood as domestic terrorist organizations. It doesn't exist. You will see, and I suspect that many of you are engaged in work that does catalog the activities of various hate groups, and I've worked at length with many organizations that do this work. However, the term hate group, from a legal perspective, has no legal significance. So that's something that's important to understand. The third point, Domestic terrorism, as I've defined it, and hate crimes, how are they connected? How are they related? Well, the key point to understand is that these concepts are not mutually exclusive. That is to say, if something is a hate crime, that doesn't exclude it from also being a potential act of domestic terrorism. So if a lot of this tends to confuse folks, because in many instances they'll see an individual like Patrick Crusius in El Paso being charged with a slew of federal hate crimes charges, and they might think to themselves, well, gosh, the federal government, is given a pass to this guy. They don't want to characterize him as a terrorist, and so they just decided to load him up with federal hate crimes charges instead. Well, that's not the truth at all. The fact of the matter is, federal hate crimes charge might be the best available statute to hand given the evidence that a particular prosecutor has. And as a consequence, that's the one that'll be charged, even though the underlying activity that perpetrator engaged in meets the statutory definition of domestic terrorism. Consequently, even though he's being charged with federal hate crimes, he would also be construed as a domestic terrorist. It's a bit of a logic train there, if you follow me a little. But that in effect, is what we have, is the work that we're engaged in. Another important point that I've already touched on, but I want to emphasize, is that the animating ideology associated with domestic terrorism is largely immaterial. That is to say, it doesn't really matter what is animating the hate that ultimately results in an act of domestic terrorism. It's so long as the individual or the group is giving expression to it through violence or the threat thereof. So we will construe individuals who do violence in the service of, say, Western lands extremism, or do violence in the service of a racially or ethnically motivated violent extremist agenda, the same manner as somebody who does violence in the service of an extreme environmentalist or animal rights agenda. The key thing that we seize on is violence, or the threat of violence.
Tom, can you talk about Adam Waffen a little bit?
That was my next point, sir.
Good.
You were reading my mind. And so that brings me to my next and final point before I turn it over to the other panelists.
Thanks.
And that is, before I pivot to Adam Waffen, group membership is not required in order to be construed as a domestic terrorist. A lot of folks think that you got to be a card-carrying member of a particular organization to be a domestic terrorist. Not so. Think about Timothy McVeigh, who perpetrated the single most deadliest incident of domestic terrorism in U.S. history in 1995. He's not a card-carrying member of any particular organization. Again, I've already talked about Patrick Crusius, not a member of an organization, yet clearly a domestic terrorist in the sense that he committed the second deadliest incident of domestic terrorism in U.S. history. That brings me to Adam Waffen. That said, and I can go into a bit more detail later on, we do have instances where there are groups that are actively collaborating to give expression to virulent ideologies through force or violence. Some of these groups include organizations like Adam Waffen was mentioned. Others include organizations called The Base, which many of you may be familiar with, and there are several others that I could note as well. In fact, and just on a positive note, I will highlight the fact that our efforts over the course of the past 2 years or so have resulted in several prosecutions which have effectively dismantled much of these organizations. But again, the nature of the charges that have typically been brought are fairly pedestrian, in the sense that they include things like immigration violations, or weapons violations, or hate crimes violations. But they still have the signal effect of dismantling some of these organizations that have dedicated themselves to giving expression to their ideology through force or violence.
Thank you, Tom. Eric and then Shirin. First, Eric, you were the Assistant Attorney General in charge of the Civil Rights Division at the Justice Department. Can you talk a little bit about what that means, what role the Civil Rights Division plays in hate crimes prosecutions, and how, maybe to just make it even more high level, those cases interact with what the National Security Division does?
Sure. So So let me take you back, Andy. I'm gonna get to that, but I'm gonna take you back 151 years to the year 1870, because I think it's important to understand why the Department of Justice exists and what it does today. In 1870, we were 5 years removed from the Civil War. The United States had just enacted 3 amendments to the United States Constitution to try to protect the rights of formerly enslaved individuals. And what the country was experiencing was a rise in lynchings and terror perpetrated by the Ku Klux Klan, particularly throughout the Confederate States former Confederate states. Congress created the Department of Justice, enacted 3 separate laws to protect the rights of those formerly enslaved individuals, and President Grant directed the Department of Justice to prosecute those cases, and within a year and a half, the newly created Department of Justice had returned 3,000 indictments throughout the South of people who had been terrorizing formerly enslaved people through lynchings, murders, and threats of violence. 86 years later, in 1957, Congress created the Civil Rights Division and enacted other various civil rights statutes thereafter throughout the 1960s. One of my predecessors, John Doerr, successfully prosecuted criminally the people who were involved in the race and hate-motivated murders of 3 civil rights workers in Mississippi, including a sheriff and deputy sheriff. Those workers were Michael Schwerner, James Chaney, and Andrew Goodman. The way it works now, the Assistant Attorney General for the Civil Rights Division is the position that I held at the department, works with the National Security Division, where Tom works, with the United States Attorneys, where Justin works, with the FBI and with state and local law enforcement to oversee, authorize, and personally certify all hate crime prosecutions throughout the United States. In 2017, in August of that year, there was a Unite the Right rally in Charlottesville, Virginia. An individual named James Field drove his car into a group of protesters, killed a woman named Heather Heyer, and nearly killed roughly 3 dozen other people. A couple of weeks later, I testified before the Senate Judiciary Committee when my nomination to serve at the Justice Department was pending, and I pledged 2 things. 1, that anyone who committed hate-motivated violence would face the full force of the law and the Justice Department, and 2, that I had not prejudged anything. And so when, a year and a half or so later, I was very proud to join with our prosecutors in the U.S. Attorney's Office, the FBI, to return the conviction and life sentence of the individual who drove his car in Charlottesville, Virginia. When I served at the department then, in addition to coordinating and overseeing the criminal section of the Civil Rights Division, what we did was we expanded the number of prosecutors dedicated to this work. So at the Justice Department, in the criminal section, devoted only to hate crimes and other civil rights crimes, we have now nearly 100 prosecutors full-time and other staff. We expanded outreach. We worked with the FBI to expand data collection, which immensely helps the FBI deal with these kind of hate crime works. And in 2020, we prosecuted the highest number of hate crimes in more than 2 decades at the department. We also, during my tenure there, prosecuted more color of law cases in a single year than ever in the department's history. And I think it's important, these color of law cases are not often grouped with hate crimes, but they involve hate crimes. These are where people using their role as law enforcement can abuse their authority to deprive people of their constitutional or other federal rights. That's what the department used to prosecute those who killed the 3 civil rights workers in Mississippi, and it's something we still use today. And so I was very proud of that work, and it was a real privilege to work with Tom and Justin and others. And I'll just leave it at that, Andy.
Thank you. Shirin, you have spent a good deal of your career teaching about and litigating on behalf of people whose civil rights have been allegedly violated as a result of this kind of work, national security work. You have written tremendously thoughtful and provoking pieces on this topic. What are your, I want you to talk about 2 things. One are your concerns, and how do you see the interplay between civil rights and national security? And 2, the other thing that we learned from you the other day when we spoke was the relatively new thinking in the civil rights community about sentencing and how an appropriate sentence for someone convicted of a hate crime might not be just more jail time. That's a lot to swallow, but if you don't mind, would you just weigh in on those 2 issues for us?
Sure. Thank you, and thank you for having me here, especially at a gathering dedicated to the memory of the Tree of Life victims. So I thought I'd actually start with just one overarching point about how we approach conversations about criminal law and justice like this one. And I actually was reminded of a quotation by James Baldwin, which I'll just share for a moment. So James Baldwin wrote, "Well, if one really wishes to know how justice is administered in a country, One does not question the policemen, the lawyers, the judges, or the protected members of the middle class. One goes to the unprotected and listens to their testimony. Ask any Mexican, any Puerto Rican, any black man, any poor person how they fare in the halls of justice. And I start with that quotation just to remind all of us that while we, including those of us on this panel, all bring relevant forms of expertise to this conversation, conversations about criminal justice in particular must include those in communities directly affected, especially in communities of color who have often borne the brunt of criminal justice decisions that have often been made by others. So I'm going to say just two things substantively. One is in reference to criminal law strategies aimed at the prevention of ideologically driven violence. And here we often see in the domestic terrorism strategy that the Biden administration unveiled, or in the commentary of national security agencies, that what we ought to do to respond to white supremacist terrorism is to expand and apply the preventative counterterrorism tactics applied over the past 2 decades against Muslim suspects and defendants. And here is where I want to urge some caution, not because applying or expanding these tactics in a different context is the problematic part, but because the tactics that have been used themselves, even as against Muslim suspects primarily in the last 2 years, actually in some cases need to be reined in rather than expanded. So I'll just very briefly address FBI sting operations because this is one of the main tactics that's been used. So FBI sting operations essentially are directed at young men who might appear sympathetic to violence based usually on their social media posts. And FBI undercover agents or confidential informants paid by the FBI typically approach such men to see if they can lead them further to agreeing to commit a criminal act. And those who take the bait are prosecuted and often sentenced to lengthy criminal terms. These are often young people who generally had no prior connection to a terrorist group, nor had taken any actual steps toward violence. So the obvious question these cases raise is whether they would have engaged in criminal conduct in the absence of government involvement, particularly when the targets are often young, in many cases mentally ill, financially insecure, or otherwise vulnerable to influence, which has often included in these cases financial inducements, sometimes fake religious guidance, and psychological pressure to overcome any reluctance. Several European countries actually prohibit these kinds of undercover operations out of precisely these concerns that the FBI and other agencies may not be preventing terrorist activity so much as inducing it. So I raise this as one of the main examples of a counterterrorism practice that's been adopted over the past 20 years and used quite extensively, but that really needs reconsideration and reining in rather than being used as a model. The second point I want to make is actually in reference to hate crimes. It's kind of broader category of racially or otherwise motivated violence against targeting victims of a particular race, sex, sexual orientation, religion, and so forth. And that category applies to a broad range of criminal conduct, including vandalism, simple assaults, and lots of other crimes that go well beyond homicide or gun crimes. Most hate crimes laws that apply at the state level function as sentence enhancements, so that if, for example, if somebody is convicted of an assault and it's proven that they acted out of bias, then they can be sentenced not just to the ordinary criminal punishment or the baseline for assault, but then an added term of prison because of the motivation. And in recent years, there has been a lot of rethinking within civil rights organizations and in various marginalized communities about whether this is, in fact, the right approach. And it's because of concerns around mass incarceration, prisons, and racial justice that some of these questions have really come to the fore. So there is, in fact, little evidence that hate crime sentence enhancements increase deterrence. And there's also concern that hate crimes charges in certain contexts may be brought disproportionately against people of color or other defendants who are already part of marginalized communities. So there is growing interest in not kind of taking a one-size-fits-all approach and advocating for maximal enforcement of hate crimes laws, and particularly the sentence enhancements, but in thinking about things like, in certain cases, restorative justice programs that can, again, in particular contexts, generate more meaningful accountability for those who cause harm, while also providing means of redress and greater victim satisfaction, in fact, for those who have been harmed. These programs aren't appropriate in every case, but especially for relatively less serious offenses or cases with younger offenders, those who aren't deeply committed to their prejudices, they may provide some meaningful closure for victims, as well as an opportunity for certain perpetrators to grow from the experience without the often further damaging experience of prison. And there is, in fact, some empirical research showing greater victim satisfaction and lower recidivism from restorative justice programs. So I'm happy to talk about any of this further when we get to there.
Thank you. I want to come back to the notion of restorative justice programs within the hate crimes context, because I think that's going to be a fascinating area as we go forward, and more of the victims that we're talking about are people of color, and more of the people we're prosecuting are people who are not people of color, and the interplay between the community sentiment and the approach of prosecutions. It's a fascinating topic. Tim, as someone who oversaw sentencings, oversaw the appeal of sentencings, the appeals of cases, you have experience both as a prosecutor but also as a judge. What about this discussion hits your experience and rings true to what you've seen in the world of terrorism prosecutions and hate crimes?
Well, yes, I have the experience of looking at much of this from the perspective of a prosecutor, from the perspective of a trial judge, from the perspective of an appellate judge. But I think it's important to understand that anyone serving in any of those roles brings with her or him life experiences that inform judgment and inform approaches to deciding issues and to addressing concerns. I am here not because I'm a former judge or because I'm a former prosecutor. I'm here, and I'm honored to be here, out of love. This is an anti-hate conference. Laws that focus on anti-hate, I hope, are born of our common love for one another and our respect for one another's dignity. It's a matter of integrity. But some of it is also a reflection of what we've learned over so many years. My family integrated the Squirrel Hill community back in 1957. We were young kids, my brother, my sister, and I, and all of my friends in the neighborhood. Many of them were, their parents were affiliated with Tree of Life Synagogue. I spent so much time at Tree of Life when I was growing up that the rabbi gave me my own tallis and yarmulke to use. We would go through a different community every Friday, my classmates and I, to attend woodshop class at a different school. And in passing through this community, my Jewish friends were called Christ killers and all kinds of other things. And of course, then when they would see me, nigger lovers. And you know what they were calling me. And so we fought. We fought together. And I still bear some of the scars from those fights. I was, I was on my way to run to the JCC in Squirrel Hill the day that the massacre happened. And I was going to run right past Tree of Life. And there were cars and sirens and everything else. And it was raining. What I'm trying to tell you is that it was a personal attack for me. And of course for the victims' families. But it was an attack on my community, my neighborhood, my friends. I knew some of the people who lost their lives. And so when I listen to references to James Baldwin, I am reminded that we would all do well to go back and read Baldwin and to read Ta-Nehisi Coates and to read more and more about our common suffering and our effort to find our way to love in order to overcome this. Hate crimes, investigations, judging, all of that stuff is important. But the bottom line is that we are in a war right now. We are in a war. Hate crimes to me are war crimes. Terrorism, domestic terrorism, white supremacy, to me, is a war crime. And judges, prosecutors, the FBI have not done enough. We have not done enough. That's, I hope, why we are here right now. And we'll be here for the coming days to talk about what else we need to do, not just in my community, in all of our communities throughout the country and throughout the world, this year, next year, and into the future. When I was on the United States Court of Appeals for the Third Circuit, I had a matter that came before me involving the Ku Klux Klan and a request by them that they be permitted to parade down Grant Street, the main street right here in downtown Pittsburgh, right past my chambers. And it was denied, and it was appealed to me, and it was an emergency appeal, and I was asked to make a decision. And my very dear friend, the head of the ACLU here in Pittsburgh, Vic Walczyk, was arguing on behalf of the Klan, standing before me in the courtroom. And it didn't take me long to grant that request, because that was my responsibility to the Constitution. That was my responsibility as a judge to do that. I was seething when I signed that order. My heart was beating so hard, and I was overwhelmed and overcome, but I signed the order. Of course I signed the order, because that's the rule of law in this country. That's what we expect from one another. That's what we have to do. But that doesn't mean that the conversation ends there. Why were they doing that? Why? There's no difference to me between the Klan and Nazis and all of these other hate groups that we are here talking about and addressing today. There are sentencing enhancement tools that are available for prosecutors to use. I consider the attack on our Capitol on January 6th to be an act of domestic terrorism. And yet you have district court judges in Washington right now who are taking different views. Some want the government to pursue sentencing enhancements with greater force. Others are saying this isn't really fair. One judge recently said the U.S. attorney in Washington would have more credibility if there were more prosecutions of the protesters during 2020 in the wake of George Floyd's murder. So you have different views, and these reflect our backgrounds and our life experience and our values. But the law is an inadequate handrail that we lean upon to seek guidance and to try to come to some determination. It is never, no matter what we talk about here this afternoon, it is never going to solve the problem of hate. We have to address the prisms that are foisted upon us at birth in this country and in other countries that cause us to look at one another differently. So you ask the question, what do judges do, what judges' perspectives and so forth, and it's important to have that conversation. But by and large, my answer is we have not done enough. We have not reached into our hearts enough. We have not brought enough out to bear through legislation, through judicial action, through prosecution, through investigation, through the work that has to be done. And also, and perhaps most important, through our common outreach to one another to learn and to grow and to do the best that we can to act as a community must act and should act through love.
And last but not least, Justin, could you talk about, as both U.S. Attorney and as an Assistant U.S. Attorney, you handled hate crimes and domestic terrorism cases, and I want you to talk a little bit about some of the issues that Shirin has raised of protecting civil liberties and civil rights and the use of sting operations, if you would, in your personal experience. And then I want to come back to both the sentencing and the civil rights issues for a final discussion before we break.
Okay. Well, what I would offer to the group here is in my experience, for much of the time that I was a federal prosecutor, and I've been a prosecutor most of my 20-year career as an attorney, for most of that time, the world really, the law enforcement world was very much divided into hate crimes, which were usually completed acts of some sort, where we were getting reports from local law enforcement if we were lucky. More often, though, we would have outreach from community groups or from victims themselves seeking some assessment of the facts in a case where there may be a federal hate crime that was in play. So in those instances, you had completed offenses. Somebody had been harmed, you had real victims in a case, you had some sort of damage. God forbid, and fortunately I never had to deal with this as either an AUSA or a U.S. attorney, God forbid you have somebody who gets hurt or killed. Those are completed offenses. On the domestic terrorism side, we very frequently employed many of the more aggressive, proactive law enforcement measures that Shirin spoke about in an effort to try to identify people who would perpetrate violence and prevent it before it occurred. And there is a tension between those two things. There's always a tension between those two things. You don't want to be, as a law enforcement official, you do not want to be in a situation where you have a completed offense that's occurred on your watch for which you are responsible in some measure, because maybe you had some forewarning, some advance idea of a plan that was being perpetrated, or someone with violent ideations or intentions. Now, I will say, in the domestic terrorism space, there needs to be some refinement, I think, going forward, and I'm actually confident that that's already underway and has been for the better part of a couple of years here. I saw it in my time as U.S. Attorney, where we were taking a much more serious approach to trying to prevent the next El Paso, trying to prevent the next Tree of Life, and trying to be thoughtful about all of the civil rights considerations that we already take into account in federal law enforcement. There's use of informants, yes, it is prolific in the national security space. In every case where you're trying to be preventative on getting out in front of an act of violence, there is probably an informant involved somewhere, maybe several informants. The one thing I would point out, though, to the crowd, though, is that on the domestic front, the tools that are available to the FBI are far more limited than they are in the international terrorism space. There's an entire infrastructure in the intelligence community that is built around pre-warnings and identifying potential threats before they ever reach the shores of the United States. And that does not exist, for very good reasons, in the domestic space. It will never exist in the domestic space as far as I'm concerned. But there are tools that are in place, tried and tested tools that accommodate civil rights, but also provide law enforcement with the ability to get out in front of some of these cases. So for instance, whereas in an international terrorism case, you may rely on something called the Foreign Intelligence Surveillance Act, which has separate approvals and a whole separate court process to approve electronic surveillance, you have to rely on traditional, what's called Title III surveillance, a wiretap, if you've ever seen The Wire, that kind of authority, in order to try to identify what is being said, to whom it is being said, et cetera. It's used all the time in drug cases, public corruption cases. And I think increasingly we'll see that on the domestic terrorism front as well. And so I think that does mitigate against the concern about the use of informants, overbearing use of informants. The FBI also has come a long way. Maybe there's more work to do on this as well, I would say, but they have come a long way in terms of ensuring that there are policies and guidance manuals in place at the FBI to address these concerns. I've tried these cases. The proof is usually very, very strong against the defendants. And the way that the law works is when you talk about entrapment, when you talk about the legal definition of entrapment, it's often really not a great defense for people to advance, because it allows essentially the defendants, things like the defendant's character and reputation, these are things that are supposed to be taken into account under the jury instructions and presented to the jury. It's not usually something that a jury gets instructed on. So by advancing an entrapment defense and asking for an entrapment instruction, very often a defendant is putting themselves at risk of the government being able to present a whole host of evidence of predisposition to commit the crime that you wouldn't otherwise see in any case. So that's why you don't typically see that defense advance or that instruction requested.
Thanks. Tim, I want to ask Shirin, and then I'll come to Tim. On the question of sentencing, I have two recent experiences that I want to run by you, both in Minnesota, both of which involved, one was an actual bombing of a mosque and the other was a threat. I handled the threat case and brought to the imams in the mosque the fact that once we had figured out who had made the threat and why he had made the threat, that this was a person struggling with mental health issues. He was angry, he was homeless, and really needed mental health care we thought, more than a lengthy prison sentence. With respect to the actual bombing of the mosque, kind of the opposite was true. And in both cases, the leadership of the mosques worked with the prosecutors and agreed on an approach to sentencing that seemed to make sense to the community and to the victims. That kind of approach, it seems to me, makes sense. It's not always going to work. What are you seeing in your work in that area?
Right. Well, a number of groups, community groups around the country already operate restorative justice programs, which divert some set of cases, whether they're misdemeanors or in some cases even felonies, outside the typical track of prosecution and criminal sentencing when the victims and the person who committed the offense is willing, when the offender acknowledges the harm and is seen as being kind of able to go through a process of meeting with the victims, again, if they consent and if they are also willing to undergo that process, with the hope of reaching a reparative agreement. In other words, an agreement that might involve things like educational requirements, counseling for the offender, sometimes community service, other measures to repair the harm in a way that is meaningful to those who have been affected by it. And these programs, some of them are dealing with hate crimes as part of the broader set of offenses that they engage. So again, not available in every case, not available for sure in a case where somebody remains deeply committed to their prejudices. But in some set of cases, they are available and provide an opportunity to actually get more of a restorative outcome to all sides. I just wanted to say, if I can, just one thing briefly in response to some of what's been said in the last few moments. And I think that the main point that I would want to make is that, the way that we frame the work that we're doing to suppress hate crimes and extremist movements and the like really does matter. And I've heard a few times now invocation of a war mentality or war metaphor framing. And I would just remind people that we have now spent 2 decades fighting a war on terror, which, by estimates of the Brown Cost of War Project and other groups, has claimed over 900,000 lives, primarily civilian. And we are also at a moment when we have had Republican members of Congress calling for a war on terrorism to be unleashed on our streets against Antifa and racial justice protesters. So when we talk about things in terms of war or in terms of applying the lessons of the last 20 years, we really need to be careful that while we may think that our tactics may be applied to just the right kinds of people who really do qualify, who really are violent white supremacists, the tendency is for tactics to get applied much more widely in a way that's often devastating for communities. I would just say that while this panel does not directly address the creation of domestic terrorism charges or expansion of FBI surveillance authority and the like, more than 200 civil rights and human rights organizations, which are part of the Leadership Conference on Civil and Human Rights, have spoken out publicly against the creation of a domestic terrorism charge or expansion of FBI investigative authority. So that has to be part of the picture, that these concerns are real and widely shared.
Well, and it's particularly meaningful when the civil rights organizations that are speaking on this topic are also representative of many of the people that are victims of these crimes. So it really is insightful to hear that. Tim, I know you wanted to weigh in on this topic.
Well, just on the last point, which is an excellent point, and I agree. When I use the term at war, I'm talking about love versus hate. I'm talking about being at war with hate. And maybe there are more gentle ways to express that sentiment and to get that idea across as to what it is that we're I hope, trying to accomplish here. But I use that metaphor because there are tools at our disposal that I don't think are taking advantage of, that we should and we must, in pursuing what I consider to be, if not a war, at least a battle, a serious battle, the same battle that Dr. King was fighting, the same battle that my dear friend Ben Jealous was fighting when he was head of the NAACP, and every civil rights leader I know and have worked with, we are all fighting together. So that's really what I'm referring to. So I agree with the larger point that was just made. Just a couple of things. On the issue of informants, I have serious concerns about the use of informants for some of the reasons that have already been pointed out, but also because we have to remember that it was really one of my heroes, Bobby Kennedy and Nick Katzenbach, when they were running the Department of Justice and pursuing civil rights prosecutions and investigations in the South. Gary Rowe, you may remember, was a Ku Klux Klan member who was recruited and did serve for about 5 or 6 years as one of the chief informants, but he actually also participated in the murder of Viola Liuzzo. He was there that night when she was shot and killed, and he was there for all kinds of other events. And over the years, and I've worked with the FBI for many years, when I was an assistant U.S. attorney here in Pittsburgh, they do great work, but it's a delicate balance between how far an informant is permitted to go in collecting data, collecting information, and using it, and when lines might be crossed, including First Amendment lines. I mean, we may hate the idea, but people do have a right to be members of organizations and have their names associated. And when you have someone who is an informant who is turning over volumes and volumes of information that have nothing to do perhaps with an underlying crime but may pertain to other things, that's a concern. So I advocate for judicial oversight of the use of informant information in federal criminal prosecutions. I think that there should be hearings before trials on exactly what the nature of the informant's work was, how long they've been an informant, what other cases they've been informants in, what their criminal records are, and so forth and so on. And there should be an independent assessment, which does happen. It unfolds that way in certain situations anyway, but I think it should unfold that way in all cases.
Thank you.
Sorry.
Tom, can you address the questions of the sort of the limits of domestic terrorism versus free speech? Something that, when I was U.S. attorney, we grappled with all the time on both domestic and international terrorism cases. Where is the line crossed between advocating your personal views and committing a crime? And can you also talk a little bit about the sentencing issue that Shirin talked about?
Sure, absolutely. With regard to the threats piece, one point I'd like to make is that we have come to the opinion, and this is not new, and we've been doing this for some time, that charging individuals with federal threats violations, and there are a range of federal statutes that have threats components to them that we can use, serves in many instances as a very effective disruption technique. That is to say, charging somebody who has been continuously subjecting, say, a Jewish American community center with a series of threats over a period of many months with a federal violation that puts that person in prison for 3 years may very well have prevented that person from otherwise walking into that building and murdering 10 people. So to the larger point, and by the way, a perfect illustration concerns the organization that you asked me to touch on before, named Atomwaffen. A couple of years ago, the Justice Department brought charges, threats-related charges, in connection with Atomwaffen.
Can you just explain what Atomwaffen is? I don't know if we did that.
Sure, absolutely. Atomwaffen is it's a broadly speaking, and some differ in terms of its charter, but it's broadly neo-Nazi in character. The term itself derives from a German phrase meaning like nuclear war. And this is a group of individuals located primarily in the United States, which are dedicated to giving expression to their neo-Nazi ideology through force and violence. And several murders have been attributed to them over the course of the past several years, for example. But in any event, in this particular instance that I'm talking about, members of the Atomwaffen engaged in a targeted leafleting campaign whereby they sent posters, placards, if you will, through the mail and otherwise to several Jewish and African American journalists throughout the country. And ultimately, the government was able to bring threats-related charges and conspiracy charges to put those folks in prison. So that's one way that we can effectively use threat statutes to shut down some of these organizations that are dedicated towards giving expression to their ideology through force or violence. Now, to the specific legal standard that touches on moving from civil litigation to criminal litigation as it concerns speech-related activity, it's complicated. But effectively, what you have to demonstrate is that an individual is engaged or is seeking to communicate what in the legal parlance is called a true threat. And there are factors that you have to consider in connection with this analysis. But once you arrive at that legal determination that this person has met those factors and the nature, the content of what they are communicating constitutes a true threat, that's actionable under federal or state law under one of these many statutes that take up threats jurisprudence. One other note one other point that I'd like to make that touches on what was previously discussed with restorative justice programs and off-ramping, and I wanted to, I'd be remiss if I didn't flag the fact that there's a brand new countering terrorism strategy. It's a national strategy that was just issued by the Biden administration not several months ago. And a considerable part of that strategy concerns prevention models. And much of these prevention models take up some of the issues that we've been discussing here in this panel today. So I would invite those, it's publicly available, that have a deep interest in this to consider that and to understand that there are mechanisms in place to give effect to that strategy as we speak. And then your other question concerns sentencing specifically.
So the difference, I mean, in cases that I've been involved with, those who came to the court with remorse, and I'm not talking about cases, as Shirin mentioned, this doesn't apply to every case, but in threat cases, in cases short of serious violence, where people come to the court and express remorse for their behavior, reject the ideology in a meaningful way that drove them to the behavior, and wanted to make amends with the victims, with the community, where there was a real sort of step away from where they have been, as opposed to somebody who really does profess to believe what they believe in and continues to harbor that ideology, that hate, and presents a risk. Do you see those as sort of differences in whether one seeks an enhancement or doesn't, whether one tries to work with the community and the victims to bring them together with the defendant?
Certainly. And again, the determination in most instances about whether to bring or seek an enhancement, and there are different types of enhancements out there that bear on this issue. You've been discussing the hate crimes enhancement. There's another one that I'm more familiar with, which is a terrorism enhancement.
Sure.
That the government can seek under certain circumstances. I won't get into the particulars, it's a bit complicated. But certainly, I think the specifics of a particular case are going to naturally govern whether the application or seeking to apply that particular terrorism enhancement in a given case makes sense. And I think that's going to ultimately resolve to a case-by-case determination based on the facts and circumstances of the information that you have at hand.
Eric, you've handled a wide range of these cases and overseen, and just so everybody understands, if it's a terrorism case, a local U.S. attorney cannot bring the case without the sign-off from the head of the National Security Division in Washington. The same thing is true of a criminal civil rights case. These are scrutinized not only by the prosecutors in the area, in the district, but also at the national level. And Eric, you had to sign off on many of these cases. Tell us a little bit about how you employed, and going forward, you see the Justice Department employing the balance between protecting the civil rights of defendants and of targets of investigations, while you're also protecting the civil rights of the citizens who were threatened or harmed.
It's an excellent question, Andy. Let me talk about that. I think Tim accurately summarized the issues about true threats. With respect to informants, true threats versus freedom of speech, with respect to informants, I agree totally with what Tim said. Informants enabled us, when I was at the Department of Justice, to stop the mass killings of people before they happened. And while it may be unseemly at times to use informants, we were able to use them to break through into conspiracies of people who were in the process of planning to murder large numbers of people. And without the use of informants, there would be virtually no other way to accomplish that. And I want to just address briefly one other matter that Judge Lewis talked about, and I thought he did so eloquently, and that is what he described as the war between love and hate. I want to describe one case that we had when I was at the department. It arose, and many of you may have heard of it. An individual named Dylan Roof in Charleston, South Carolina, went to Mother Emanuel Church, a very historic African-American church in Charleston. There were 12 African-American worshipers at the church who welcomed him into that church. He came, he worshiped with them for 45 minutes. He pulled out a gun, several guns, started shooting people. He killed 9 of the 12 individuals in a matter of minutes. There was one individual there, cowering in fear, and he said to her, quote, "Have I shot you yet?" And she said no. And he told her to shut up, and he said, "I'm going to leave you here to tell the story." We were able to prosecute that case successfully there, and just recently the U.S. Court of Appeals for the Fourth Circuit affirmed the conviction. And I just want to read what the court said. "No cold record or careful parsing of statutes and precedents can capture the full horror of what Roof did. His crimes qualify him for the harshest penalty that a just society can impose. We have reached that conclusion not as a product of emotion, but through the analytical process which we've endeavored to detail here." And that goes also to the point that Judge Lewis talked about, which is the importance of the rule of law. There are times when we have no other choice in what I agree is at times a war of love against hate. And in this case, love triumphed. But I want to talk about very briefly, just beyond just what happened in the prosecution, the other parishioners at Mother Emanuel Church in the aftermath of that horrible shooting, the families, the community in general, came together and displayed a very inspiring message of love to all of us at the Justice Department and to the community and the world at large that I think speaks to the humanity of all of those people and to what this war is really about.
Black folk have been finding their own restorative justice ever since we've been in the United States of America, ever before there was a United States of America. And that is absolutely true, and what you just said speaks directly to it. And it also speaks to how those survivors were able to look Dylan Roof in the eye at his arraignment and say, "We forgive you. We forgive you because God asks us to do that." What a powerful, powerful act of love that was. I don't know that I am capable of that. But that's what they did. And so restorative justice can come from the law, it can come from our leaders, and it can also come from within.
But you were also capable of signing an order that allowed the Ku Klux Klan
That's right.
to march. So, and that's pursuant to the rule of law. And just to close on this, the concept of the rule of law and how it plays in, I think hopefully people are getting to see the tension between wanting to aggressively protect our communities, protect victims of harassment and threats and violence in the name of an ideology or in the name of hate, but also the great power that the government brings to this task and the enormous resources and the ability of bringing criminal charges. It sort of surpasses and overstates anything else in the law that we have. So with that, Justin, I'm going to ask you to say a word, and then I'm going to have Shirin, I'm going to give you the final word on this panel to talk about the rule of law and the protection of our society from hate, but also the protection of our society from the deterioration of civil rights at the same time.
Well, I've had to follow the judge twice now, so that's not an enviable position to be in. But I will say this, just to backstop, his experience and what he's relayed to us. I feel very confident in our society's ability to weather the ideological storm here. I think when you talk about the disagreements, the arguments, the pure hate and violent invective that's being foisted upon us by these other forces, I have no doubt that the people who are on the right side of this, people in this room, are going to prevail. I've never had any doubt about that because we've done it before. We've prevailed in the Civil War. We've prevailed against the Ku Klux Klan. We've prevailed in the civil rights struggle. We've prevailed time and time again. And yes, does every generation have to step up and do it? Unfortunately, that is the case. But I don't doubt where we end up at the end of the day. These are ultimately losing ideologies. And you can see that by the people who perpetrate them and the people who continue to try to maintain them. So I don't worry about that. I don't worry about it because of the rule of law. I don't worry about it because as long as we're in a position to have strong law enforcement who act to prevent violence and to be there to hold accountable people who would threaten to harm our neighbors, I think that we will ultimately get through this. It's not going to be fun. None of us wish we were along for the ride on this, but I think every voice counts, and let's make sure that all of ours are heard.
So, Professor, you have a classroom of rapt students in front of you. What message do you want to deliver based on your work and your scholarship?
I think I would complement the optimism that some have shared recently with just a reminder of how much work we have to do, and that work is not just about addressing the extreme forms of ideologically motivated violence, but that work is much more fundamentally in reconstructing our society in a fundamentally more racially just and equitable way. And in some sense, it is almost, it's not easy, but it is sometimes mentally comforting to focus on the threat of pure violence itself. It's somewhere where people can agree that we've got a problem and agree that it needs to be addressed. But below the surface, there's fundamentally much more racial injustice that as a society we need to address and actually remedy. So I guess my closing thoughts are just that our focus cannot just be on the violence. It has to be much more fundamentally in coming to terms with our long history of racial injustice through such measures as potentially a reparations commission to talk about our much more deeply seated histories of racial injustice and oppression. And that's actually the real work, far more structural, far more wide scale in scope than addressing just those who take up violence itself.
Thank you. So the bottom line here is as we look to the government and as we look to the criminal law to eradicate hate, we have to keep our eyes on how those laws can be used for other purposes, how the power of the government has to be carefully scripted. We have to be careful as we protect civil rights to protect civil rights for all, even those who, as Tim so eloquently told us, are abhorrent to our beliefs. And if you think that's easy, good, then I know Shirlethia invited everybody to become part of the civil litigation. Join the government, become part of the solution on the criminal side. And really, when I was U.S. attorney and I hired people, I obviously looked for intelligence and experience, and I'm sure my colleagues here would agree. Most importantly, what we need in government and what we need at the Department of Justice is judgment. People who will think carefully and will think long and deep about the kinds of tools available to the government, the kinds of power that the government has to eradicate hate while protecting us all and protecting our civil rights. Thank you.